So how do you dispose of your knickknacks, your personal property, things sitting around the house that may have low monetary value but have some sentimental value? What do you do about that in the context of your estate planning here in Georgia? Hi, I'm attorney Joel Beck with Peach State Wills and Trust, a division of the Beck Law Firm LLC in Lawrenceville, Georgia. And in today's short video, we'll answer that question. So when you look around your house, you've got all kinds of stuff, tangible personal property pieces. There may be jewelry and watches, some artwork, knickknacks, vacation souvenirs, tools, equipment, all that kind of stuff. And maybe for a lot of that, there's really not a lot of monetary value, but there may be some sentimental value to you or others in the family. Or you want to have some of these things go to different people in your family so that they can remember you by. What do? Do you have to put all of that in your will, or is there another way? Well, in a nutshell, for gifts to be enforced as part of your will, it needs to be specifically mentioned in the will. For example, if you wanted to leave your brother Danny your hand tools, then you would have a provision in the will that says, I leave my hand tools to my brother Danny. If you wanted to leave all of your costume jewelry to your niece Catherine, you would have a provision that provided for that. Alternatively, of course, you can actually give those things to people before you pass, and then it's not part of your probate estate once you die because you no longer own it. You gave it away. But what do you want to do if there's just too much stuff to go into your will specifically, if you want to make some decisions later, or you just don't think things are valuable enough to mention in the will? Is there another way? Well, there is, to some extent. You can, in your will, indicate that your executor may find with your will and other important papers a personal property memorandum signed and dated by you, indicating some specific pieces of personal property and your intended beneficiary. And then you request that your executor, the personal representative for your estate, follow that memorandum and distribute assets in accordance with it. Now, what you need to know is that in Georgia, that can't specifically be enforced. And so if there is a challenge, then all of your bequest in that personal property memorandum may not hold up. And the reason being is because that memo was not included in the will as signed and dated and witnessed as part of the will itself, and so it's not fully legally binding. But having said that, that does the trick in a lot of circumstances, and your executor and your family and loved ones will want to honor your wishes in a lot of circumstances. Now, certainly if there are items that are of great monetary value or that you absolutely, without a doubt, want to make sure go to a particular person, then we recommend that those things be specifically identified in the will. If you've got questions about estate planning in Georgia or need to get yours done, I invite you to give us a call. You can reach us at 678-344-5342. Or if you're just starting the process of learning what you need to do and how this whole process works in Georgia, you need to download our free guide to estate planning in Georgia. You can do that online at peachstatewills.com. Just visit peachstatewills.com, click on free info at the top to request our free guide. We'll send it to you via email, no strings attached. Thanks.